This trips me up every time because I don't know how to move this guy. Ah, there we go. All right, so tonight we're going to be having our second lecture. This one is on torts. I'm anticipating the structure of this lecture to be pretty much the same as last night's lecture. Again, anticipating it'll be around 4 hours long. I know I definitely want to take a break around that halfway point, but I also might add in some other breaks in between just because these concepts are a little more difficult than criminal law, at least in my opinion. And so I want to give you guys the opportunity to kind of digest. Sometimes when you first have something thrown at you, you don't know what questions you have until you kind of sit with it for a minute. So we might take some more breaks tonight. I'm also just kind of going to play it by ear and see how we do on time. So again, feel free to ask questions throughout the lecture, take notes. Outlining would be preferable, but at least take notes. Again, want to just briefly go over what our goals are for these lectures, right? You don't have to completely understand everything. You definitely don't need to be memorizing it or ready to use it in an exam setting. Just introducing you to the skills, really that thought process like we were talking about last night of asking why and breaking the rules down into keywords, breaking them down into elements, asking those questions, starting to understand how the rules can be applied to different factual scenarios, and starting to kind of do a little bit of that work yourself. Again, I really do not want you guys to be overwhelmed. Sounds like, we have good feedback from last night's lecture. We want to keep that. I want to keep this being a positive experience. Michelle, me and Davina were talking before you got on about how, she's glad that this is her experience. I was telling her, most people, when you start law school, it's like you're so excited, you've worked so hard for this moment, and then you start law school and it almost feels like you got hit by a truck because you're just inundated with so much reading to do. You feel very lost. And so my hope is that this makes your introduction to law school a positive experience, and then it translates once you actually start real law school, and just makes it that much easier for you guys. Getting into some tips for torts now. First of all, I want to discuss what is tort law in the first place. So torts can really be separated into three main categories. They're really just civil causes of action. To give you some examples of regular torts that you'll see is like maybe medical malpractice, or you'll see car accidents is a good one, civil assault. Those are all torts. Battery, there's civil battery, that's a tort. You see nuisance a lot. If you don't know what nuisance is, it's when someone who is like your neighbor has something going on their property that infringes on your rights to have peaceful and peaceful enjoyment of your property. So that's just to give you a general idea of what torts are. And then I like to separate it in my mind, separate it into those three categories. So the first one is intentional torts. Those are causes of action that someone does intentionally, right? They mean to do the act. They may not necessarily mean for the result, but they intend to do the act that causes the result. Depends on the tort, right? And then you have negligence, things that someone does accidentally or they're negligent, meaning that they fail to use what we call a reasonable standard of care. They fail to act reasonably. And we're going to get into all this, but I want you to kind of get an idea of where we're going. Then that third category is strict liability. And we've already touched on that when we talked about that case where the doctor implanted a medical device that was defective. There wasn't any evidence that they did that negligently, right? That they made any mistakes when they were implanting the device. That's why the negligence cause of action, if you remember, failed, because she had brought 3 causes of action. So in order to prove negligence, you have to prove that someone failed to act reasonably. So in that case, that didn't work. There was no negligence there. So they were discussing in that case just the strict liability portion, which is there's no negligence. They didn't intentionally harm anyone. We're just going to hold them strictly liable because of the circumstances. We're going to hold them accountable anyways, even though there's no proof that they technically did anything wrong. It's more of a public policy decision. You don't get into strict liability until 2nd semester. You also don't get into things like nuisance, and there's other causes of action as well. But those are like the 3 main categories for torts. Tonight, we're just going to be focusing on intentional torts and negligence. Okay, so tort law is similar to criminal law in that it's very element-based, which means you have a tort, it has different elements that need to be satisfied, and that's it. But unfortunately, it's not quite that simple, but just generally that's the framework. Just like how you have a crime, we talked about murder, and you need an unlawful killing, human being by another, and malice, right? So same thing for torts. Torts to me are harder to understand conceptually, especially when we start talking about negligence. So the concepts themselves are difficult, but then that also makes it hard sometimes to understand the framework for negligence, how you would approach that issue in an exam setting. On the other hand, tort law is not as archaic, and the rules are not weirdly phrased like how criminal law is. Like how we talked about last night, the rules for nighttime and dwelling, how they're very specific. We don't have that same problem in torts, so it is different in that way. On a more practical level for torts, you want to keep an eye out for this concept of transferred intent. This is when we're talking about intentional torts only. What transferred intent means is that when a person, there's rules for certain torts, just certain intentional torts that say when a person means to do one thing and something else happens, that's going to satisfy the element for intent. Because again, these torts have to be done intentionally. So intent is a requirement in order to find that tort. You can definitely expect to be tested on negligence for torts. Just like murder, just know that that's going to be on the table. And with that said, make sure you understand it, understand the rules, make sure you understand that framework. You want to make sure you have somebody look over your negligence approach so you know that you're on the right track. For me, I really struggled trying to figure out, okay, what do these rules mean? How are they all organized? How do I use them? And it was really helpful to me to look over practice exams because different exams test different issues, right? Within the main framework of negligence. So by looking at different practice exams and sample answers, I was able to get bits and pieces of how the framework of negligence should be for the entire thing, right? Remember, some rules you always need to talk about, but there's other rules that only need to be talked about depending on the facts. So it's really helpful to look at sample answers for that reason. And then I also took that a step further because I wanted to be sure of my approach. And so I actually had my torts professor look it over for me, which was very helpful and very kind of him to do. And he looked it over. He let me know where I was wrong. This wasn't in a practice exam setting. I said, here's my approach by itself, the entire thing. Can you please look this over and let me know, am I on the right track? He was happy to do that for me. And that gave me a lot of confidence going into my torts exam because I'm like, okay, I at least know that I've got negligence correct. I'm on the right track. I have the rules right. It's just a matter of the application. So as far as understanding negligence, because like I said, these concepts are more complicated than criminal law, again, in my opinion, I would recommend using the cases to help you understand and memorize the rules. You don't have to know the case name per se, but just the scenario of the case. I talked about earlier when we went over the law school glossary, I was talking about res ipsa loquitur, which means the thing speaks for itself. That's something we talk about in negligence. And the way I always remember that is because there was a case where there was a large piece of furniture, like a dresser or something, that fell off of, I think it was a hotel balcony. I have no idea what case that was. I don't remember anything else about the case, but it helps me remember what res ipsa loquitur means. It's a scenario where you don't know what happened. You don't know how that piece of furniture fell off the balcony. But you know, that's something that wouldn't happen unless somebody was negligent. So that's what I mean when I say use the cases to help you memorize and understand the rules. Don't get yourself stressed out feeling like you have to memorize cases per se, as far as memorizing the case name and all these details, just those factual scenarios that help you recall quickly. And then lastly, and this is important for every class, but especially in classes like this where the material is just hard to understand conceptually, is really make sure you understand the rules before you practice applying them. Take that effort in the beginning so that you're not practicing the wrong skills over and over again, because once you get yourself into those bad habits, they're harder to correct. Do you guys have any questions so far?
No, nothing from me.
Okay. All right, so here are all of the intentional torts. We have assault, battery, false imprisonment, intentional infliction of emotional distress, trespass to land, trespass to chattels, and conversion. So we're going to be talking about the first six. We're not going to be talking about conversion in detail. Conversion is very similar to trespass to chattels. The only difference is it's more severe. So that's a scenario where you have to make this judgment call of, is the trespass so severe that it amounts to conversion? Is the damage to the property so severe that it results in conversion and wouldn't be trespass alone? And we'll talk about that a little more when we get into that, but I just wanted you guys to know off the bat, we're going to just be discussing the first six tonight. Okay, so these are just some basic definitions that I want you guys to understand. These are required for every tort. Some have contact as a requisite element, some don't. But for every tort, you need intent and an act. Intent is the desire or knowledge with substantial certainty that the requisite result will occur. So what that means is that it's highly likely that the result will occur. The requisite result being what is required by the tort. So to give you an example, even though we haven't gotten into this tort yet, intentional infliction of emotional distress. That's some intentionally, right? Trying to cause emotional distress to another person. So the requisite result would be emotional distress. You have to have either a desire or know that it's highly likely that the victim will have severe emotional distress. With assault, there needs to be harmful or offensive contact, and we'll get into that, but I just want you guys to get an idea of what this intent definition means. You need harmful or offensive contact. So then the requisite result would be harmful or offensive contact, right? They have to have a desire or know that it's highly likely that they would have, that the victim would have harmful or offensive contact. The second definition we're talking about here is act. An act is a volitional movement. That just means an intentional movement. Someone does something willingly, not accidentally. They didn't slip and fall and slide down a hill or something and then crash into the victim and batter them. They intentionally did the act. And then contact is putting a force into motion. Contacting something closely associated with the plaintiff will suffice. And we talked about this when we were talking about assault in criminal law, where it's enough if you pour the water on the floor and it causes the person to slip and fall. You don't have to directly touch them. It's enough that you're the person who poured the water on the floor and then it resulted in the person slipping and falling. Okay, any questions before we get into assault?
No.
Okay. So again, this is civil assault, right? And it's intentional inducement of plaintiff's reasonable apprehension of harmful or offensive contact. So if you recall last night's discussion about criminal assault, there were two kinds, right? There was an attempted battery, and then there was intentionally placing someone in fear of an imminent battery. One was trying to batter someone and failing for some reason. The other one was based on the victim's fear of being battered. Civil assault here is just that fear of harmful or offensive contact. It doesn't just have to be harmful. It could be something that is offensive. So the elements for assault are intent, act, right? We just talked about those. The plaintiff's reasonable apprehension, and then harmful or offensive contact. So again, an example would be swinging a bat at someone, making them afraid that they're going to get hit by the bat. They would have to intend for the plaintiff to be apprehensive or afraid of harmful or offensive contact. Whatever behavior they're doing that's making the person afraid has to be done of their own free will. You have to be doing that willingly, intentionally. And the plaintiff's fear has to be objectively reasonable. Okay, so again, we have a definition here for contact. That's putting a force in motion. They contact something that's closely associated with the plaintiff, that will suffice. So what that means is something maybe physically on the plaintiff. For example, if you pants someone, that's not harmful physically, but it's offensive, right? And it's enough that you touch their pants. You don't have to touch their person, their body. Harmful contact is contact that causes injury or inflicts pain. This is contact that is physically painful on their body, harming their body physically. Offensive contact would be contact that offends a reasonable person's dignity. So we talked about some of these thought processes last night. And again, I want you guys to start getting in the habit of doing that. Looking at these rules, right? You could have two different kinds of contact that satisfy the element. The harder one would be offensive contact. It's clearer to find harmful contact. That's more straight and to the point. But it's a little more difficult to figure out whether something is offensive. So what I'm saying that because this is where, again, you spend your time in the exam. Any questions on that before we get into battery? Okay. So battery is intentional, harmful, or offensive contact with the plaintiff. Again, the elements are intent, an act, and you need harmful or offensive, that's a typo there, harmful or offensive contact with the plaintiff. An example would be hitting someone with a bat instead of just swinging at them, trying to make them afraid that they're going to get hit. So that intent would be the intent for the plaintiff to have harmful or offensive contact. Again, the act has to be something that they do volitionally, meaning of their own free will, willingly. And again, there's two kinds of contact. It could either be something that's harmful or simply offensive. Do you guys understand the difference between assault and battery?
I think so.
Okay. It's kind of similar to the concept of like attempt, where an assault is like you're intending to make the person afraid of something. But as far as when you at the facts, to me, it's helpful to look at it as an attempt. It's not the same thing. So I don't want to confuse you, right? Because assault, civil assault, it's not enough that they attempted a battery. They have to intend to make the person afraid. So there's that difference. But when you're looking at a fact pattern and you're trying to figure out what tort is at play, when you see behavior that looks like an attempted battery, you should be thinking, okay, I should probably be discussing assault. That's probably what that is.
You said attempted battery is assault? Is that what you just said?
So at criminal law, it is.
Oh,
In tort, it's different. So remember, in criminal law, there's two kinds of criminal assault, either an attempted battery or making someone afraid that they're
Right.
going to be battered. Civilly, and in tort law, there's just one kind, but it's just the fear of receiving harmful or offensive contact. But there's two kinds of contact, right? It's not just harmful contact, it's also contact that's offensive.
okay.
So it's not similar to an attempt in that way, but the factual scenario that you would see in a fact pattern would be similar. So when you're seeing someone swinging a bat, right? That looks just like an attempted battery. Do you get what I'm saying? The act itself, when you see it, you're like, oh, that looks like they tried to batter someone and they failed.
Mm-hmm.
So you should be thinking, okay, assault. But civilly, it wouldn't be an assault unless they actually tried, they did that with the purpose of making the person afraid that they're going to get hit.
So, I'm trying. So what's the difference between what's the difference between a civil assault and a criminal assault? Like,
So, and you might want to, this might be something that's helpful to like kind of map out. So for criminal assault, there are two kinds. You have attempted battery, right? Swinging the bat and missing.
battery.
And then you have attempted battery, and then you have intentionally making someone afraid that they're going to be battered.
Okay.
So that's like flashing a gun or swinging the bat at somebody, making them think, oh, I'm about to hit you, being afraid that they're going to get hit. Now, civilly for torts, there's one kind of assault, which is making someone afraid. We don't have the attempted battery. You have to intend to make the person afraid. You're threatening the person. So there's only one kind, but then of that kind, you also can have the contact that they're afraid of be something that's just offensive. It doesn't necessarily have to be harmful, which that's not the case in criminal law. In criminal, it has to be physically harmful contact.
Oh, I see. Okay. Okay, I think I get it.
And when we think of offensive contact, it's something that would make someone maybe extremely embarrassed or would just offend a person's dignity, like pantsing someone that would offend a person's dignity, or making someone think that you're going to soak their clothes with water in public or something like that. It's not physically harmful. So it wouldn't qualify as a battery at criminal law. But civilly, that would be, or I'm sorry, it wouldn't qualify as an assault or a battery, but civilly, it would be a battery. It would be offensive contact. And if you attempted to do it for the sake of making the person afraid, then it would be a civil assault. So I hope I didn't confuse you guys by bringing an attempt, but I think it was helpful that we had that discussion because it can bring forth those questions. What I was trying to say is that I want you guys to be thinking about what that would look like in a fact pattern, like in an exam setting. It can be hard sometimes to issue spot. So look at the facts and go, okay, I understand the factual scenario, but what exactly am I supposed to discuss? Your professors are not always going to tell you what to discuss specifically. They're not going to always say, is the defendant liable for assault and battery? They might literally just say discuss. So you have to be able to look at those facts and see, oh, okay, that's assault. I'm going to need to talk about that.
Mhm.
So even though it's not the same as an attempted battery, the facts might make you think about attempted battery, even though it's not. Just the facts might kind of raise the general issue because it's factually similar. Then that's how you know you need to talk about it. But then when you talk about it, make sure you have your ducks in a row as far as this is civil and not criminal.
Yeah, can you give another example of the difference?
Between civil and criminal assault.
Yeah, yeah.
Okay, let's see here. Which part of it are you struggling with? Are you struggling with the attempt part? Are you struggling with the harmful and offensive contact?
No, I'm
Or,
the attempt part.
okay. So attempting to do something means that you tried to complete an act, but you were unable to complete it for whatever
Mhm.
reason. So you're swinging a bat at somebody and they dodge out of the way.
Mhm.
You try to punch somebody, they dodge out of the way. Or you try to hit them with a gun and somebody pushes you away or something like that.
Mhm.
Because criminally, the contact has to be something that would be harmful. So you're trying to harm somebody in some way and you're prevented from doing that.
Okay.
So criminally, the person has to be physically harmed. Does that answer your question?
So, and for the civil, they don't have to be physically harmed.
Mhm. They don't. They can either be physically harmed or it could be offensive contact.
Okay. So how do you know, because if it's harmful contact, so how do you know, but since, hold on, let me rephrase my question. So with criminal assault, yes, physically harm, but also under the civil assault, there's also harmful contact. So how do you know, how do you tell the difference?
Well, you won't be required to discuss both,
Mhm.
right? Because you'll have an exam for torts
Right.
and you'll have an exam for criminal law, and they'll be totally separate. You
Okay.
could have that as an issue down the road in the bar exam
Yeah.
because you do have exams that cross between multiple courses. I don't think that they generally do that with criminal law and tort law.
Mhm.
It's more so like you always need to discuss remedies. You'll see a lot of professional responsibility being tied into other areas of law. But to answer your question, it wouldn't be challenging to do that if you knew the difference, right? As long as you know the difference, you would be able to determine whether it's civil or criminal. Now, if it's contact and it's battery, then it could qualify as civil and criminal battery,
You
right?
you cut out. I'm sorry. I don't want
Um,
to make you repeat it, but you cut out.
Okay, can you hear me now?
Yeah.
Okay, so if you were in a scenario, just hypothetically, you wouldn't be put in this scenario unless you took the bar exam, and it's not really likely that you would be put in this situation. But if you had this scenario where you have harmful contact, just let's talk about battery, right? If you had harmful contact, it could be criminal and civil battery.
Okay.
Now, the more severe in the real world, the more severe the contact is, the harm is, the more it will be criminal versus civil.
Okay. That's a good way to understand it.
Now, if you see contact that is just offensive and not physically harmful, then you know it can't be criminal, so it can only be civil.
Okay.
If you see someone attempting to do something, not intending to make someone afraid, attempting to do it, not I'm swinging the bat at you because I'm trying to get you to get out of my way and I'm trying to scare you off. That's trying to make someone afraid. But I'm just trying to hit you and I miss. That can't be.
Oh, okay. I get it now.
Okay.
Okay. Okay, that was a good, okay. So let me just say it back to you so I understand this. So
Yeah.
criminal assault, it's like basically you're hitting to and that's your intention is to hit somebody, but you miss. But for the torts assault, it's like you said, you're just trying to, tell people to get out of your way, basically.
Yeah, you're just threatening someone.
Yeah, you're not intending to hit them. You're just like making them fear that bat so they would, kind of okay. Okay, I think I get it now.
Okay. So one clarification that I want to make sure you understand, when you're talking about criminal assault, you have this option. There's two kinds, right? So there's the I'm not trying to make someone afraid, right? I'm just trying to hit them. But you also have the I'm trying to make someone afraid and thinking that they're going to get hit. There's both for criminal. At
Right.
civil, there's just making someone afraid. You don't have the other kind, which is the attempted battery.
Okay. I think I understand it now.
Okay.
Thank you. That aha moment. Okay.
Look for those moments.